We're live. Hey, Charles. First of all, hey, everybody. Welcome to Your Legal Tea. I have a special guest today. He looks very dapper and very serious right now. Charles Hubley. Should I call you Charles? Is there anything else? Is there another name I can call you?
Amber, you are a close friend. You can call me Chip. Absolutely.
Perfect. Now, can anyone else who calls your office, can they call you Chip, or do they need to call and say, hey, Charles?
They can call me Chip. They can call me whatever they want if they need help.
Perfect. Okay, so Charles, can you do me a favor and just explain to people what you do? I know what I do. I'm an employment law attorney. I represent people with discrimination issues, and I know you have it's not a specialization, but you practice a certain area of law. Explain to them what you do. Explain to them a little bit about yourself too.
Yeah, absolutely. So I represent folks who have been injured, either in the scope of their employment under workers' compensation, or in car crashes, premises liability cases. You walk into a business's premises and you get hurt in some way. I represent folks who have found themselves in those unfortunate situations. So I do that across the board.
Okay, so you deal with a lot of injuries. I know a particular portion of injuries are workers' compensation injuries, so people who have been hurt on the job. Is that correct?
That is correct.
Okay, good. I'm going to ask you some questions pertaining to that specifically, because that's not what I do at all.
Sure.
I just want everyone to know I refer all of my workers' comp cases to Chip, because that's not what I do, and I stay in my lane, and I let the professionals handle that. So my first question, Chip, is what should a person do when they're injured on the job?
Well, the absolute first thing that you need to do is make sure that you tell your employer about the injury. Mm-hmm. It happens all the time. I have people come in and they say, Chip, I got injured. It was about 3 months ago. Mm-hmm. I'm having back problems. What am I supposed to do? And my first question is always, have you told your employer? Some people say yes. Some people say no. Mm-hmm. Under the Workers' Compensation Act, you have a certain amount of time that you need to tell your employer. It's important that you do that. So the first thing is to tell your employer and make sure that you make a report about it, because that kind of gets the case moving in the right direction.
Okay. One thing I always get from people who call my office is, does the report need to be in writing? Or what's the benefit of having it in writing? Does it have to be in writing for it to be an actual legitimate report?
No, my understanding of the case law and the Workers' Compensation Act is it doesn't need to be in writing. You can tell your supervisor, hopefully there's a witness there to say, hey, I saw so-and-so. Tell their supervisor that they were injured on the job. That is important. Building up the case, building up the evidence is always important. Putting something in writing is always beneficial because it's right there. We can send it over and say, look, here's when it happened. Here's the date. It was told from this person to this person. Those things are always important as well. So it doesn't have to be in writing under the act, but it is beneficial if it is.
Right. I always tell people, look, it does typically, complaints don't have to be in writing. I'm sure this is what it sounds like for workers' comp, but it will never negatively impact you if it is in writing. So I always say, be safe. It's better to be safe than sorry. Put it in writing.
Absolutely. Best evidence, right? Put it in writing, and then they can't dispute it
at all. Even if they try, they might still try to dispute it, but you got it in writing.
They probably will. So,
will workers' compensation cover an employee for work-related illness or injuries that aren't a result of an accident that happens at work?
So it has to be in the scope of your employment. So let's say you're a delivery driver. Okay. And you're out delivering something on behalf of your company, and you get in a car crash. That should be covered under workers' compensation. There are some areas where it might not be covered, but for the most part, if you're in the scope of your employment, it should be covered under workers' compensation, and your employer should pay for your medical bills and medical treatment.
Okay. Can a employee receive workers' compensation benefits if the accident was actually the employee's fault? Like it was totally their fault, no fault of anyone else's. Can they still receive workers' comp?
Yes, absolutely. So it's a no fault system. So it really doesn't come down to whether you're at fault or, I have a lot of machine guarding cases. People get their hands stuck in things and they suffer really terrible injuries. You can't really blame anybody for that. And most of the fault would probably fall on the employee. But yes, workers' compensation should cover those injuries.
And this goes back to, I don't do workers' comp. So, what if is there a kind of this is kind of legal, but is there a kind of mirroring, or where's negligent and torts law when it comes to workers' comp? Is it just like totally separate? You can't file a negligence claim against your employer, and it's just workers' comp, or how does that work?
So for the most part, that's correct. Okay. So the act was put right. The act. It's like I'm taking a law school exam. This is good. It's getting the synapses firing. So, the Workers' Compensation Act was put in place, and basically it was put in place to take away the worker's obligation to sue their employer and prove any type of negligence. So, the idea of the act is, in exchange for not having to prove that your employer is at fault, and getting you these benefits, which are supposed to be, kind of immediate and start helping you immediately, but doesn't always happen, unfortunately. But in exchange for having to prove those things against your employer and getting you the treatment that you need in the scope of your employment, you give up some rights, one of which is the ability to sue your employer for negligence. So they also there's also some other take backs from the employer. They get to direct your treatment. They get to tell you which doctors to go to. They make a decision as to how much treatment you get based on those doctors, and some other things. But there's a give and take under the statute.
Okay. And that was leading to my next question. So a person cannot see their own doctor. Is that true?
So it depends. Okay. It's
the favorite lawyer answer. It depends.
I know, of course, there's always a gray area under the law, right? Which is why we have jobs, Amber, so that we can exploit those gray areas. But it's like, I have cases where folks come in and they have talked, I have somebody who called me a few days ago and she said, I've been injured, Chip, and I had prior back surgeries. And 2 prior back surgeries. And my prior doctor who did my back surgeries is who I wanted to have another back surgery done after I got hurt on the job, and my back surgery injuries were affected by my work. So in the instant, at work comp, the insurance company sent a doctor, a surgeon, orthopedic surgeon, out to see her and evaluate her at the hospital. And that doctor took a look at her and he talked to her, and she said, look, this other doctor actually did my surgery prior to this. Do you think you could talk to the insurance company and get that other doctor on my work comp case? I think that's probably the best scenario going forward. He's already been inside my back, more or less.
Right.
He helped me out. So in that instance, that doctor that the work comp insurance company had sent went back to the work comp insurance company and said, I think that the best scenario here would be to bring her old doctor in, because he knows all about her treatment already. And if he's willing to do it, I think we should bring him in. So the work comp insurance company agreed, and they had this third surgery that she had to have. My goodness. Her doctor who had done the previous surgery was the doctor that did that surgery. So there are scenarios where you can use your own doctors. But again, for the most part, the work comp insurance companies like to use their own doctors because they have a little bit of control there,
Right.
And patients. So I'd say the exception to the rule would be using your own doctors, but and for the most part, you have to use the doctors that work comp sends you to.
Okay, perfect. So I have a question that was just sent from us from a person who's watching. And they ask, can an employee get a lawyer after their case is closed if they have pain and trouble after the treatment is complete?
Yes. Well, it depends.
Maybe.
There's different types of settlements. I would need to know the specifics of the settlement. But you can reopen a case under certain scenarios. If there was fraud on the part of the insurance company in getting you to sign that settlement and close your case, they misrepresented something to you, then you may be able to open it again. if you have an ongoing injury or a change in the status of your injury, it gets worse or it gets better or something like that, or you have complications, you may be able to open the case back up and be reevaluated. So there are scenarios where that can happen.
So if that happened to you, and we have a question out there, give Chip a call, and he may be able to see if that's something that is an option for you.
Sure.
Also, next question. Okay, what kind of benefits can a person or employee receive under workers' comp?
Sure. So there's a couple different things that you're entitled to under workers' compensation. First off, you're entitled to temporary total disability benefits, which is basically a wage replacement. So in the event that you get so injured on the job that you can't complete your job duties and a doctor that work comp sends you to says that, then they are obligated to pay you temporary total disability, which is typically 66 2/3 of your wages. So I'm sorry, you froze up there for a second, Amber. So
I'm back. You're
back. I just want to make sure you were hearing me. So that's kind of a wage replacement, and the thought is it's 66 2/3 because it's they're accounting for your federal and state taxes on 1/3. So you get 66 2/3% of your wages for as long as they find for you to be temporary totally disabled from being able to complete your job duties, and then they send you back to work. So there's that benefit. And then depending on the outcome of the case and how injured you are, you may be entitled to permanent partial impairment benefits, which is essentially it's kind of a complicated process, but the work comp board puts out a formula for different body parts and how injured you are. Okay, so you're going to get, I know it's strange.
There's value to like your hand, your finger.
Exactly. Your lower extremities, your upper extremities, your back, your whole body. There's a whole formula that goes into it. So everybody loves formulas. I'm a lawyer. I'm a lawyer for a reason. Not great at math, good with words and letters. So, but there is a formula that comes into play, and it'll be based on what your doctor under workers' compensation, how impaired you are. So if you, let's say you're 30% impaired of the whole body, they will give you a PPI rating of 30%. And plug that into the formula that is put out by the Workers' Compensation Board, which is approved by the Indiana legislator. It's all legislated, and it kind of spits out a number. And to kind of make it easy, that's what you're worth to the insurance company at the end of the case. They say, okay, there's this formula, and you're 30% impaired. We're going to pay you X amount of dollars, and send you on your merry way. Those are the two types of main benefits you see in work comp cases. There are total disability benefits. There's if you're totally disabled and you can never work again, there's some ongoing benefits that you can receive, and things of that nature.
Okay. And then they cover all your medical expenses. Is that correct too?
Yes, they have to pay your medical bills. Of course. Yeah, that's the big thing. People are like, who's going to pay my medical bills? And it should be your work comp insurance carrier that covers those medical bills straight up. They should pay everything.
Okay. My other question is, will the person be able to go back to their old job?
Yeah. I mean, after they go through the work comp system, which is not beneficial to workers in Indiana, in my opinion, for different reasons. Sometimes they don't want to go back, and they're like, this has kind of left a bad taste in my mouth. I'm not really crazy about my employer right now, but there are people that say, hey, look, I love my employer, they've done right by me, I want to go back. And absolutely, you go back. Once you're released by your doctor, you go back to work, and hopefully you don't get injured again or re-injured that injury that you had previously. So
another thing, I tell people all the time is, if you do go back and you may need restrictions, that could be an ADA thing. So workers' comp and the Americans with Disability Act, they kind of play off each other to a certain extent. So I tell a lot of employees who have dealt with workers' comp that if you do go back to your employer and you made an accommodation to do your work, then request an accommodation when you do go back and just engage in what we call the interactive process. So that's really important if you do go back to your old job.
Absolutely. And if in that same vein, if they give you restrictions, stick to those restrictions. You know, if that doctor that work comp sent you to says, look, no heavy lifting over 10 pounds or 15 pounds or whatever, or don't do this, stick to those restrictions, because, you know, your employer could use that against you later if you don't do those things. So,
Okay. They can use it against them. Okay.
yeah.
Okay. My last question is, sometimes I will say, does a person need a workers' comp attorney? But I really think it's when. Like, when should they contact a workers' comp attorney to get help? Because this is kind of sticky situations. Employers, I mean, I don't know how open they are to workers' comp claims. I do tons of litigation, so they're never open to it, and I'm sure you're dealing with the same thing. So it's like, when should they say, look, I need to talk to an attorney because I'm just not, I don't know if I'm not getting what I need, or they just have, it's not intuitive. Like, they don't, like, you have these equations. It's not an intuitive process. So when should they contact an attorney?
So it's that is a good question, and I get that all the time. I have folks that call in, and they say, you know, I got hurt at work. What do I do? And you know, that's, if you really don't know what to do, if no one from HR has told you, hey, look, you know, our work comp, we've made a work comp claim. Here's what's going on. We're going to send you to treatment at this facility on this date. You absolutely should contact somebody, because it sounds like, you know, work comp is not doing what they're supposed to be doing. And that does happen. I have people that call in and they've reported their injury, and they were told by their manager, who they trust and somebody who they've worked with for quite a long time, we're going to take care of you, don't worry, and then nothing happens, which isn't good, you know. So obviously in that scenario, you should contact somebody to help you kind of figure out this work comp scenario and this issue. Other times I have people call in and they say, you know, hey, I've been treating for about 3 months. It's going well. They're paying me my temporary total disability because I can't work at this point in time. I just don't know what to do. And I don't know, if everything's going right. And I usually ask those questions. Are they paying you your temporary total disability? Are you off work? Are you satisfied with the treatment you're getting? Are you satisfied with the doctor that you have? Do you feel like you're being treated correctly? Are they being upfront and honest with you? And if those things are happening, I'd probably say, look, why don't you call me once they release you from treatment? Because at that point in time, they're going to give you that PPI rating, that permanent partial impairment rating. And sorry, downtown Indianapolis, they're doing all kinds of work there. So hopefully
no problem.
Yeah. But at that point in time, they've given you that PPI rating, and I won't be able to tell you exactly what's going on because I won't have all your medical records, but I can kind of give you a ballpark of whether they're being honest with you or not. I mean, depending on the severity of your injury and what the doctors have told you and how much ongoing or future medical treatment you may need, I can kind of give you a ballpark of whether it's a good PPI rating and whether you should take it or not take it. And if it's a bad PPI rating, then maybe at that point in time, we sign you up. We send you for an independent medical examination from a doctor that, you know, we think may give you a better PPI rating, and we can fight that with the insurance company before the board. So
that's perfect.
Yeah.
Another question we receive is there a time period to reopen the case if you have been seeing the same workers' comp physician for the initial injury up till now? So I don't know, is there a time period you can open up the case to get it reevaluated, I guess?
We have 2 years from the date of the injury to file the case.
Okay.
You know, I don't know if I have a good answer for reopening the case. I mean, frankly, you should probably do it as soon as possible if you feel like it's necessary to reopen it and you feel like maybe you need a change to your condition. I'd do it as soon as possible.
Okay. Perfect.
I hope that answered the question.
I think so. Chip, thank you so much for joining this week's Legal Tea. I really appreciate it. You've given such valuable information. Seriously, like, I get questions and I'm like, I don't do this. So I was like, I need to make sure I have Chip on here because you're who I refer all my workers' comp cases to. So is there any other information you think people need to know about workers' comp or about you and your practice?
You know, I try cases, and not every lawyer does that. So I know a lot of people on TV say that they are, you know, the biggest law firm or they're the baddest law firm or whatever, but some of those people don't try cases. So just folks keep that in mind. And I love to help people, and that's what we're here to do. So I would love to work with more folks. And I do want to tell you, Amber, I sent somebody over to your office today for some disability problems they may be having with their employer. So that's who I send people to.
Thank you so much, Chip. I really appreciate it. And thank you everyone who's joined the live stream. I'm going to post it. It's going to be on all forms of social media. Please look at it. And Chip, we have someone who says she's going to call you soon. So good. We already have somebody who's in the queue for you. Awesome. If anyone has any questions regarding workers' comp, call Chip. I'm going to put his contact information in the comments below all of our videos, just to make sure you have that easy way to communicate with him. And it's always, everyone, enjoy your lunch break. Have a great day. Thanks so much, Chip.
Thank you, Amber. Tell Marcus he owes me a round of golf, okay?
Will do. Bye.
Bye.